the right of access to children. Should we still be referring to it as the right of access? Let's talk about that. Hi, I'm Daniela. I'm a litigation lawyer specialized in family and child law. At our firm, we strive to support our clients along with representing them diligently in their legal disputes. So, the right of access to children is basically the time that the children will get to spend with the parent with whom they are not residing. Now, the days and times of the right of access are either agreed upon between the parents on a contract, or else they are determined by the family court in a court decree. Now I'm raising the issue whether we should still see it as a right of access of the parent due to the many disputes that I have seen clients go through once the parent is exercising this right of access. And unfortunately, I have seen clients that are not treated equally by the law. What do I mean? So, if the parent with the right of access goes to pick up the children and the other parent, for whatever reason, does not allow the children to go for access, then that parent with the right of access can go to the nearest police station, file a police report, and criminal charges are filed against the other parent. However, this situation, this remedy, does not exist in the reverse. So, if the parent with the right of access, for no valid reason whatsoever, does not pick up the children for access, or picks up a time at their convenience, ignoring the times agreed in the contract or in the decree, notwithstanding the repercussions that action has on the other parent, that parent cannot file a report at the police station and have proceedings against the parent with access rights. So I have seen clients being at the back and call of the other parent, which often misfortunate consequences, such as missing important appointments. I had a client who also lost a part-time job. So, and we have to acknowledge that this can also be a situation of abuse and control, where when one parent, for no reason other than to control the other parent, simply does not show up or shows up at a completely different time to what is agreed. Now here we're not talking about being a few minutes late because you caught up at work or caught up in traffic, but we're talking about consistently, regularly ignoring the times in the decree or the contract and doing what is convenient for that parent. So recently, for example, I had a client whose child was supposed to have a sleepover and she had her own plans. At the last hour, the father informed her that he was not going to pick up the child for the sleepover, but he was going to pick her up very early the next day to go about their plans. Now, when my client went to the police station, they told her that as long as the father picks up the child within the hours of the access, so here we're talking about a 24-hour span because it was a sleepover, they could not do anything about it except take a report simply for record purposes. So here, again, my client was at the back and call of the other parent, had to abandon her plans at the last minute and had to wake up the child early at the as instructed by the other parent. Now, obviously, we have to acknowledge that this is not the reality for all parents, and that there is also a heart-wrenching reality where, despite having a right of access, that parent cannot exercise that right of access due to the actions of the other parent, what we refer to as parental alienation. And about that, I will do a whole different video because there's a lot to be said. But basically, the parent with whom the child is residing, consciously or unconsciously, adopts strategies to harm the relationship between the child and the parent with access. And this might lead to a situation where the child, him or herself, disowns the parent and does not want to spend time with the other parent, does not want to go for access. And this is the situation then that it is presented in court. In such situations, it is crucial for court to act sensitively, but more importantly, effectively, because the more time passes, the more harm is done and the more difficult it will be to repair that relationship. We also have to acknowledge that there is a third reality. That is that because of the feelings and emotions that the children themselves have, which might be anger, abandonment issues, having witnessed domestic violence, and much more, it could really be the child, him or herself, that does not want to go to access. And therefore, I believe that in such situations, it is the responsibility of the court to analyze what reality is being presented, what is the true reality in that situation, and act accordingly. Now, if you have found this video useful, please like and leave us a comment in the comment section below with your feedback or your experience. Lastly, please remember that this video is intended only for informational purposes, and this was intended to be construed as legal advice. Thanks for watching.